A blockbuster visual effects vendor dispute. A jury finds Disney vicariously liable for copyright infringement tied to facial capture software used on Beauty and the Beast. The district court later granted judgment as a matter of law. Then a Ninth Circuit panel reversed and reinstated the verdict. Today, we unpack how the court got there, why the Ninth Circuit panel concluded Disney had the ability to control its VFX vendor, and what this means for studios and VFX houses going forward. I'm Scott Hervey of Weintraub Tobin, and today I'm joined by my partner, Tara Sattler. We're talking about Reardon versus Walt Disney Pictures on this episode of The Briefing. Tara, welcome back to The Briefing.
Hi, Scott.
I think this one's gonna scare you like it did me, or at least make you concerned for some of your studio clients. And it's probably going to change the way that studios diligence VFX providers. All right, so quick context. Reardon is the company behind the MOVA Contour. It's a facial motion capture system. So, physical capture rig plus software program. And it's used to translate an actor's facial motion into files that animate CG faces. Reardon registered copyright in the MOVA software in February 2016.
The core storyline is messy here and Hollywood-ish. MOVA's assets moved through a series of companies. In 2013, the MOVA assets were transferred by a former Reardon employee, Gregory LaSalle, who operated the MOVA system on previous studio projects. Shortly thereafter, and against Perlman's wishes, LaSalle surreptitiously organized a sale of the MOVA assets from MO2 to a DD3 affiliate company. LaSalle then joined DD3 and continued operating the MOVA system.
Right. And Perlman was the operator of Reardon. Okay. So we've got this ownership dispute between DD3 and Reardon regarding the MOVA operating system. While that ownership fight was still in the background, Disney hired DD3 as a VFX vendor for the 2017 Beauty and the Beast production. DD3 performed 9 MOVA facial capture sessions on set. Disney representatives, notably director Bill Condon and visual effects supervisor Steve Gaub, they were Disney's designated picture representatives. They attended and reviewed MOVA output during these sessions. Disney's contract with DD3 gave Disney broad contractual rights, weekly progress reports, review of work in progress, the right to request changes, and termination rights for copyright infringement. Might I add, like, these are pretty standard studio terms in any type of studio VFX agreement.
That's just what I was going to say. That agreement seems about what I would expect.
Yeah.
So on set, there's evidence that included a click-through copyright notice on the on-set file players stating copyright 2016 Reardon LLC each time data files were loaded. And DD3 was paid roughly $31 million for its services on Beauty and the Beast, nearly half of the VFX budget for that element of the film.
Right. So Reardon sued Disney in 2017, alleging that each time DD3 ran MOVA on set, it created unauthorized copies of the MOVA software, so the theory of direct infringement, and that Disney was vicariously and contributorily liable for DD3's conduct. After a 2-week jury trial, the jury found Disney vicariously liable and awarded Reardon a little over $250,000 in actual damages and returned an advisory verdict on profits of $345,000 and some change.
Okay, so despite that jury verdict and the jury's advisory profits finding, the district court granted Disney judgment as a matter of law. The court's short answer was Reardon had failed to show Disney had the practical ability to identify and therefore supervise or stop the infringing conduct. The court emphasized prior Ninth Circuit tech platform cases that limited vicarious liability where the defendant lacked any realistic ability to locate and remove infringing content. The district court framed the issue like this. In order to control infringing content, one must be able to identify the infringing conduct. That makes sense to me.
Yeah, it does, right? So practically, the district court credited Disney's argument that studios can't feasibly investigate every piece of software used by hundreds of vendors on big productions. That makes a lot of sense. And that studios lacked a specific reason to doubt DD3's representation that it had the right to use MOVA. The court thus concluded no reasonable jury could find the required practical ability element of vicarious liability.
So that all makes sense to me, but the Ninth Circuit panel reversed the judgment as a matter of law and reinstated the jury verdict. But the panel did not invent new law. Instead, it walked through the vicarious liability standard. The plaintiff must show one, a right and ability to supervise the infringing conduct, and two, a direct financial interest in the infringement.
Critically, the panel explained that the control requirement demands both a legal right to stop infringing conduct and the practical ability to do so. The court expressly recognized the line of Ninth Circuit cases that limit liability when a defendant cannot realistically identify infringement, but it concluded that on the record here, and given Reardon the benefit of all reasonable inferences, there was legally sufficient evidence for a jury to find that Disney had the practical ability to supervise DD3.
So, what drove the panel? I think there were several concrete threads, and these are emphasized because they're the kernel of the decision. So, the first is actual supervision and presence on set. Disney personnel, Bill Condon and Steve Gobb, attended every MOVA session and reviewed on-set MOVA output. The activity occurred within Disney premises that were controlled and patrolled. The court analogized this to Phonovisa's swap meet vendor control and Napster's ability to search indexes. If the defendant can reasonably see the activity, that favors vicarious liability.
Contractual powers. Disney's DD3 contract gave Disney express rights to review work product, require turnover of work product, and terminate for copyright infringement. The panel emphasized that those legal rights are part of the right and ability inquiry.
The other element the panel emphasized was size and economic leverage. Disney used only 4 VFX vendors on Beauty and the Beast, DD3 being one of the 2 largest, paid around $31 million. Facts, the panel said, made vendor oversight more feasible than Disney argued. The jury reasonably could find Disney could perform targeted due diligence on a major vendor.
Another factor that was relevant here, and this one seems highly relevant, was publicly available red flags. So Reardon introduced evidence of a public dispute over MOVA, including a 2015 Hollywood Reporter article in which Reardon's founder, Perlman, said DD3 lacked a license. And this was published about a month before Disney contracted with DD3. The panel said that a reasonable jury could infer that Disney knew or should have known of the ongoing dispute and therefore had reason to investigate. That's a very compelling fact, for sure.
It is, I agree. Another element that the panel focused on was those on-set copyright notices. Reardon presented evidence that click-through Reardon copyright notice appeared on on-set computers each time that MOVA data was loaded. The panel said the jury could reasonably credit that Disney personnel could have seen the notice if they had exercised their contractual review rights. Put another way, the jury could have reasonably concluded that Disney had the practical ability to see this notice.
I could see a jury pairing these onset notices with the publicly available red flags and really finding that, you know, Disney should really have investigated DD3's license status. That I can see that being highly persuasive.
Think this one particular argument, though, is a little bit attenuated because, as you and I know, the business affairs folks and the lawyers are often negotiating contracts and seeing which entities are entering into contracts, not necessarily the creative folks on set. So, if folks on set are seeing a copyright notice with a company name, they might not necessarily know that that is a different name than what's in the contract. So,
I agree. No, I agree. And also, every time we get a VFX agreement for one of our clients, we don't do a Google search to see if there's some type of public dispute. I mean, it might have been just by happenstance that one of the BA executives on Beauty and the Beast saw this Hollywood Reporter article and put the two and two together. But I could see a jury being persuaded by these two elements.
and not really understanding how it practically goes down.
Right, right, for sure. Um, okay. So the Ninth Circuit also reiterated the principle from Napster it found instructive. So turning a blind eye to detectable acts of infringement for the sake of profit gives rise to liability. The panel said Disney's argument that it would have been impossible to identify infringement across hundreds of vendors was undercut by the reality of this production. A small set of major vendors, heavy financial investment in DD3, on-site supervision, contractual termination rights, and public notices, all of which could support a finding of practical ability.
So the Ninth Circuit did not hold that every studio is automatically vicariously liable whenever a vendor infringes. Instead, it held the jury had a legally sufficient basis to find liability here because of the totality of the specific facts pointing to Disney's practical ability to stop or limit the conduct. The panel put it succinctly. Reardon introduced sufficient evidence for a jury to conclude Disney had both a legal right to stop or limit DD3's infringing conduct, as well as the practical ability to do so.
All right, so let's talk about some takeaways for our type of clients, production companies and studios. Um, so what should a studio or producer and VFX houses take away from the Reardon decision? I think that there's going to have to be at least a minimal amount of targeted due diligence when there's a VFX hire. And all of our clients that listen to this podcast, I think you're going to have to get your post-production supervisors and post team into diligencing their VFX vendors before they agree to hire them. The panel signals that large buyers who heavily rely on a small set of vendors, I would even just say who rely on VFX vendors, especially high value vendors paid tens of millions, I might even say millions or hundreds of thousands, should conduct at least a targeted IP due diligence on core vendor technologies. Or I might say a due diligence to make sure that there's no public dispute regarding the IP that will be used in your particular production. If there are public disputes or red flags, as we see here, ignoring them can be dangerous. And I might add, if there are public disputes and if they are in a uh, uh, a periodical or journal like the Hollywood Reporter or Variety, industry Bibles, I think the court's going to impute knowledge.
Yeah, I mean, it seems like here even a pretty quick Google search would have at least pulled up that Hollywood Reporter article.
Right.
So I agree with you. I think another takeaway is that production companies and studios should exercise their contractual rights. So, broad contractual rights to review work product, receive weekly reports, inspect systems, and terminate for infringement are meaningful. The key is not just having those clauses on paper in the deal, it's actually using them when indicated. The court emphasized that Disney's contractual rights were relevant to the right to supervise portion of the inquiry.
So, document supervision and reviews. If supervisors attend capture sessions and review footage, document that review and document what you saw or didn't see. Well, yeah, probably easy. This is easy for us to say, but probably hard to do. The presence of Disney reps at capture sessions and on-set file displays were central to Reardon's argument, right? The whole fact that the splash screen said copyright Reardon 2016 or 2015 or whatever it was. Absent contemporaneous records, a jury might credit plaintiff's testimony that these notices were visible.
I think another takeaway is to use careful vendor management and indemnities, but don't just rely on those alone. Disney had indemnities contractually, and DD3 represented it had rights, but the panel reiterated that indemnities and contractual assurances are not a get out of free card. So courts expect that the party that profits from the activity will take responsible steps to police infringement.
That's kind of scary, right? That you can't rely on the representations and warranties made by a large VFX vendor that you're hiring, that the court, that you're actually going to have to conduct your own due diligence. Um, that, I mean, that's, yeah, that's concerning. Okay. Insurance and contractual allocations are still important, while not a shield from liability. Well-drafted indemnities, warranties, and audit rights and insurance can help allocate risk, and if exercised, can demonstrate that a studio conducted proper oversight.
So I think the bottom line here is that this ruling increases exposure where a studio uses a small number of core VFX vendors, pays those vendors large sums, has contractual and on-site access to the vendor's work product, and faces public or on-site indicia of potential rights problems. When those factors are present, a jury could conclude the studio had the practical ability to police the vendor and that they should have done so.
Right. And if I may add, I think the bottom line takeaway here as well is that uh, you need to due diligence your VFX vendors before they get hired. And that should just be part of the post-production workflow is a quick Google search to make sure that there's no outstanding disputes regarding the vendor's core IP, especially if that IP is going to be used on your production.
Yes, absolutely.
Well, thanks, Tara, for joining me today. Always great to have your insights. I think this one is particularly relevant to the types of clients you and I have. And thank you to our listeners for joining us on the briefing. If you found this episode helpful or interesting, please take a moment to subscribe, like, and share it with your network. We also would love to hear from you. Leave us a comment or a review and let us know what topics you would like us to cover in future episodes. I'm Scott Hervey. See you next time on the briefing.